Cornell Law School. UCC, Article 2A, Leases, Part 2. Formation and construction of lease contract, Paragraph 2A-201. Statute of Frauds. 1. A lease contract is not enforceable by way of action or defense unless a. The total payments to be made under the lease contract, excluding payments for options to renew or buy, are less than $1,000, or b. There is a writing, signed by the party against whom enforcement is sought or by that party's authorized agent, sufficient to indicate that a lease contract has been made between the parties and to describe the goods leased and the lease term. 2. Any description of leased goods or of the lease term is sufficient and satisfies subsection 1b, whether or not it is specific, if it reasonably identifies what is described. 3. A writing is not insufficient because it omits or incorrectly states a term agreed upon, but the lease contract is not enforceable under subsection 1b beyond the lease term and the quantity of goods shown in the writing. 4. A lease contract that does not satisfy the requirements of subsection 1, but which is valid in other respects, is enforceable, a. If the goods are to be specially manufactured or obtained for the leasee and are not suitable for lease or sale to others in the ordinary course of the lessor's business, and the lessor, before notice of repudiation is received and under circumstances that reasonably indicate that the goods are for the leasee, has made either a substantial beginning of their manufacture or commitments for their procurement. b. If the party against whom enforcement is sought admits in that party's pleading, testimony or otherwise in court that a lease contract was made, but the lease contract is not enforceable under this provision beyond the quantity of goods admitted, or c. With respect to goods that have been received and accepted by the leasee. 5. The lease term under a lease contract referred to in subsection 4 is a. If there is a writing signed by the party against whom enforcement is sought or by that party's authorized agent specifying the lease term, the term so specified. b. If the party against whom enforcement is sought admits in that party's pleading, testimony, or otherwise in court a lease term, the term so admitted, or c. A reasonable lease term. Paragraph 2A-202. Final written expression, PAROL or extrinsic evidence. Terms with respect to which the confirmatory memoranda of the parties agree or which are otherwise set forth in a writing intended by the parties as a final expression of their agreement with respect to such terms as are included therein may not be contradicted by evidence of any prior agreement or of a contemporaneous oral agreement, but may be explained or supplemented, a. by course of dealing or usage of trade or by course of performance, and b. by evidence of consistent additional terms unless the court finds the writing to have been intended also as a complete and exclusive statement of the terms of the agreement. Paragraph 2A-203. Seals inoperative. The affixing of a seal to a writing evidencing a lease contractor and offer to enter into a lease contract does not render the writing a sealed instrument, and the law with respect to sealed instruments does not apply to the lease contract or offer. Paragraph 2A-204. Formation in general. 1. A lease contract may be made in any manner sufficient to show agreement, including conduct by both parties which recognizes the existence of a lease contract. 2. An agreement sufficient to constitute a lease contract may be found although the moment of its making is undetermined. 3. Although one or more terms are left open, a lease contract does not fail for indefiniteness if the parties have intended to make a lease contract and there is a reasonably certain basis for giving an appropriate remedy. Paragraph 2A-205. Firm offers. An offer by a merchant to lease goods to or from another person in a signed writing that by its terms gives assurance it will be held open is not revocable, for lack of consideration, during the time stated or, if no time is stated, for a reasonable time, but in no event may the period of irrevocability exceed 3 months. Any such term of assurance on a form supplied by the offeree must be separately signed by the offerer. Paragraph 2A-206. Offer and acceptance and formation of lease contract. 1. Unless otherwise unambiguously indicated by the language or circumstances, an offer to make a lease contract must be construed as inviting acceptance in any manner and by any medium reasonable in the circumstances. 2. If the beginning of a requested performance is a reasonable mode of acceptance, an offeror who is not notified of acceptance within a reasonable time may treat the offer as having lapsed before acceptance. Paragraph 2A-207. Course of performance or practical construction. 1. If a lease contract involves repeated occasions for performance by either party with knowledge of the nature of the performance and opportunity for objection to it by the other, any course of performance accepted or acquiesced in without objection is relevant to determine the meaning of the lease agreement. 2. The express terms of a lease agreement and any course of performance, as well as any course of dealing and usage of trade, must be construed whenever reasonable as consistent with each other, but if that construction is unreasonable, express terms control course of performance controls both course of dealing and usage of trade, and course of dealing controls usage of trade. 3. Subject to the provisions of Section 2A-208 on modification and waiver, course of performance is relevant to show a waiver or modification of any term inconsistent with the course of performance. Paragraph 2A-208. Modification, rescission and waiver. 1. An agreement modifying a lease contract needs no consideration to be binding. 2. A signed lease agreement that excludes modification or rescission except by a signed writing may not be otherwise modified or rescinded, but, except as between merchants, such a requirement on a form supplied by a merchant must be separately signed by the other party. 3. Although an attempt at modification or rescission does not satisfy the requirements of subsection 2, it may operate as a waiver. 4. A party who has made a waiver affecting an executory portion of a lease contract may retract the waiver by reasonable notification received by the other party that strict performance will be required of any term waived, unless the retraction would be unjust in view of a material change of position in reliance on the waiver. Paragraph 2A-209. Leasee under finance lease as beneficiary of supply contract. 1. The benefit of a supplier's promises to the lessor under the supply contract and of all warranties, whether express or implied, including those of any third party provided in connection with or as part of the supply contract, extends to the leasee to the extent of the leasee's leasehold interest under a finance lease related to the supply contract, but is subject to the terms of the warranty and of the supply contract and all defenses or claims arising therefrom. 2. The extension of the benefit of a supplier's promises and of warranties to the leasee, Section 2A-209, 1, does not, I, modify the rights and obligations of the parties to the supply contract, whether arising therefrom or otherwise, or 2, impose any duty or liability under the supply contract on the leasee. 3. Any modification or rescission of the supply contract by the supplier and the lessor is effective between the supplier and the leasee unless, before the modification or rescission, the supplier has received notice that the leasee has entered into a finance lease related to the supply contract. If the modification or rescission is effective between the supplier and the leasee, the lessor is deemed to have assumed, in addition to the obligations of the lessor to the leasee under the lease contract, promises of the supplier to the lessor and warranties that were so modified or rescinded as they existed and were available to the leasee before modification or rescission. 4. In addition to the extension of the benefit of the supplier's promises and of warranties to the leasee under subsection 1, the leasee retains all rights that the leasee may have against the supplier which arise from an agreement between the leasee and the supplier or under other law. Paragraph 2A-210. Express Warranties. 1. Express warranties by the lessor are created as follows. A. Any affirmation of fact or promise made by the lessor to the leasee which relates to the goods and becomes part of the basis of the bargain creates an express warranty that the goods will conform to the affirmation or promise. B. Any description of the goods which is made part of the basis of the bargain creates an express warranty that the goods will conform to the description. C. Any sample or model that is made part of the basis of the bargain creates an express warranty that the whole of the goods will conform to the sample or model. 2. It is not necessary to the creation of an express warranty that the lessor use formal words, such as warrant or guarantee, or that the lessor have a specific intention to make a warranty, but an affirmation merely of the value of the goods or a statement purporting to be merely the lessor's opinion or commendation of the goods does not create a warranty. Paragraph 2A-211. Warranties against interference and against infringement. Lessee's obligation against infringement. 1. There is in a lease contract a warranty that for the lease term no person holds a claim to or interest in the goods that arose from an act or omission of the lessor, other than a claim by way of infringement or the like, which will interfere with the leasee's enjoyment of its leasehold interest. 2. Except in a finance lease, there is in a lease contract by a lessor who is a merchant regularly dealing in goods of the kind a warranty that the goods are delivered free of the rightful claim of any person by way of infringement or the like. 3. A leasee who furnishes specifications to a lessor or a supplier shall hold the lessor and the supplier harmless against any claim by way of infringement or the like that arises out of compliance with the specifications.